Good morning, everybody, and welcome to this Zoom session hosted by the board this morning, the training division of the board. This session, as those that have registered all knows, this is regarding the new fees that took effect on the 8th of July. And right from the start, allow me just to welcome everybody, fellow sheriffs, colleagues, admin staff, deputies. Thank you very much for taking the time and the effort to join. Mr. Murigan, thank you very much for your presentation that is going to take us through this fee increase. Mr. Nell and his team for the preparation. And I hope you find this informative and of assistance, and that it will assist you in changing the fee structures in your office. Without further ado, allow me to introduce you and welcome Mr. Advocate Mark Morgan this morning. Sir, it's great to have you on the session with us. And without further ado, over to you, sir. Thank you.
Good morning, colleagues. Thank you very much, Program Director, my honorable board member, Mr. Ian Burton, for that warm welcome. Good morning, colleagues. Good morning. A special word of welcome to Mr. Alan Murigan, who will be facilitating this training today, informative training. Good morning to Mr. Nall as well, the person that ensured that today's training becomes a success. We are always in fact, I'm always on behalf of the board indebted to you, Mr. Nall, for the great work that you do in ensuring that sheriffs are trained. And then good morning as well to colleagues, sheriffs that are present, fellow board members, deputy sheriffs, office staff, everyone that is here today. Good morning. I don't have much to say. I didn't come prepared. I didn't prepare a speech, let me put it that way. But I'll speak off the cuff. I have read the sheriff's increases from the rules board, but I noticed that travel expenses were not covered. And that was the one question that I posed to Mr. Nall even before he had to say, why aren't they covered? He's informed me that our submission is still before the rules board for consideration. Hopefully it will be considered as well and they'll come back to us. But colleagues, thank you very much. I think the increases that were effective as of last week, Friday, the 8th of July, come in at a time where they are needed the most for most sheriff's offices. In fact, our country is not in a good state in terms of recession has hit us, or is about to hit us, if I can put it that way. Inflation is high. Therefore, it cannot, sheriffs are not immune, or practices are not immune from these adverse financial impacts. So, Mr. Murigan, please take us through this training, conscientize us, or the sheriffs more, on how properly they have to charge in line with the increases, because I know from the board side, we've gotten a couple of questions and concerns from sheriffs that say the offices are non-viable, whatever, and even, it goes to even affect the legal obligations declarations if increases are not factored into and reported by sheriffs, because then you'll report a lesser income, pay lesser obligations, which also has an impact on the running of the board. So it's very important and crucial that sheriffs charge the correct amounts, take into regard the increases. I've had a visit in a couple of sheriff's offices, and I could see some of them from their returns. They still have old, outdated tariffs. And obviously, in that case, there's no way, but you're operating at a loss. They'll always complain to say the offices are non-viable, when a solution is already ready and it's presented to you. The only thing that is left is for one to implement, say. So thank you very much for this opportunity, Program Director, Mr. Nall and Mr. Murigan. And I wish you the best of luck in presenting this training to us. I'll be joining for the duration of the training as well. Thank you very much.
Thank you very much, Chairperson of the Board, Advocate Mark Morgan. We are most grateful to you for giving us your time this morning. Also, welcome to, and not good morning, it's actually afternoon, it's after 12. So, Mr. Burton, thank you, Chairperson he's the Chairperson of the Training Committee. We also welcome all our other board members. And of course, we welcome all the sheriffs that have joined us this morning. I went through the list. Let me see now. I'm told 167 people have in fact registered, but I only see Adrian. Oh, I see Amish from our office, Anita, Annette, Annelien Rudolph, Anton Greiling. Haven't seen you for a long time, sir. Ashraf Dawood, one of our senior facilitators, assessors. He'll be in action on the Sheriff's Introductory course soon. Wow, Bronwyn, Christo, Cindy, Courtney, David, John, Herman, hallo almal, hoe gaan het met julle? Grenville Miller, our HR manager, is also online. That's great. The South African Board for Sheriffs staff has also joined us. That's good. So I see we've got 93 participants. I don't know where we are in respect of load shedding in our country. So although 163 have registered, let's give them an opportunity. And I'm sure that they will join us when they can. So just some notes from my team. And my team is very small this morning. It's only Lucinda Dalport and Candace George. They are manning the session behind the scenes. They tell me it goes absolutely crazy because sheriffs register last minute. You mustn't register last minute. You must register in time. In fact, we're going to send you an invitation tomorrow for a session on the POPI Act, or PIA. So please register in advance. That's only going to be on the 16th, but register in advance. So for now, just some housekeeping. So what we'd like you to do, the ladies have asked me to please check with you. If you go to your screen and you go to the top right-hand side, the top right corner of your screen, there's a little button there with the word view. If you click on that, they would like you'll see attendee view. First, it's my view and then attendee view. Now, make sure that those are on on side by side or speaker, because once Mr. Murigan comes on, and I'm going to introduce him shortly, we'd like you to be able to see him as the facilitator. He'll come on the right-hand side of your screen, but on the left is his PowerPoint presentation. So we'd like you to make sure that you click on the attendees view for speaker so that you can get both. It'll be speaker or side by side. It'll come up as side by side, I think it is. And then I see Veliswa Balduza is also online. That's awesome to see. She was the first ever CEO of the South African Board for Sheriffs many years ago. So from Lucinda and Candace, they've asked me to just mention to you that an evaluation form will be on the link, and they're going to put it in the chat link. It is important to note that at the bottom of your screen, you've got on the left-hand side, you've got mute, then you've got the next button is stop video, then you've got participants, then you've got Q&A, question and answer. So when you have a question for Mr. Murigan in respect of the slides that he's going to share with you and the comments that he's going to make, put your questions in the Q&A. Type it in there. Do not put it in the chat. I'm going to monitor the Q&A for you, for Mr. Murigan, and I will read out your questions if it makes sense. If it doesn't make sense, I can't read it out. But if you put your question in the chat, I'm not going to see it. So type questions in the Q&A and not in the chat function. The chat function, an evaluation form will be placed in there, a link to the evaluation form. Please complete that for our administration. And whilst I'm talking about the registration and evaluation forms, there was a question as to why do we ask for race and age and province. That those details that we ask you to complete on the registration form is not for the South African Board for Sheriffs. Those are actually for the SASITA, whom we report to annually by the 30th of April every year. And they want the details. They want to know how many people have joined, from which province they are, what the age groups were, the race groups were. So that is what that particular detail on the registration forms are for. Okay, so the last thing is, pose your questions in the Q&A. Pose those questions there. Mr. Mulligan, please. He is an ex-board member. He was, of course, like Ian Burton, he too was the previous training chairperson. He's a senior material developer for the South African Board for Sheriffs. For the South African Board for Sheriffs, or for profession, I suppose. He's also currently representing the South African Board for Sheriffs at the SASITA, and he has currently been elected, and we congratulate him for being elected as chairperson to the Legal Services Chamber at the SASITA. He's a facilitator, of course, and that's why he's going to facilitate today. I welcome him, Mr. Alan Mulligan, who is the Sheriff of Durban North and Acting Sheriff for Durban South. Mr. Mulligan, good afternoon to you, sir. Mr. Mulligan, please make sure that you are unmuted.
Good morning, Mr. Nell. Thank you very much for the introduction. Can you hear me, Mr. Nell?
Perfectly, sir. Thank you very much.
Okay. Thank you very much. Thank you for the introduction there. The chairperson of the South African Board for Sheriffs, Advocate Mark Morgan, Deputy Chairperson, Mrs. Titus, Mr. Ian Burton, the Training Committee Chairperson, board members present, Mr. Nell, the Training Manager and his staff, Sheriffs, Deputy Sheriffs and Office staff. Good morning to you all. As you know, I am Alan Mulligan, the Sheriff of Durban North, and also a facilitator who will be facilitating this session on behalf of the South African Board for Sheriffs this morning. Welcome to this question and answer session on the Sheriff's tariffs. Colleague, I'm now going to put my slideshow on so that we can go to the tariffs together. We will go through as Mr. Nell pointed out and the chairperson of the board pointed out, that this session is set up to assist sheriffs understand the tariffs and obviously and most importantly implement these tariffs in the most profitable manner. As was pointed out earlier to you, the country is going through a very bad time. We're almost at the door of recession, and obviously sheriffs operating their offices would like to be financially viable. Looking at the tariffs that was gazetted on the 3rd of June under Gazette number 46475, which took effect on the 8th of July 2022. Percentage of increase, although we know it's fairly low as compared to the current financial situation we find ourselves in, but it's something for us to move a little further than we were. Pointed out to us that the traveling fee obviously was not considered. I am aware that few submissions were made, but please do not ask me when we're getting traveling fees, because I would not be able to answer you. It's something that is an ongoing discussion with the various stakeholders. Colleagues, I'm going to go through the fees in detail. We're going to start with the I-Court fees, Rule 68 of the Act 59 of 1959. We will go through each tariff and obviously try and explain to you where you can use it and how you can use it. And obviously, if possible, time permitting, we can take as much questions and queries that you have, and obviously the most suitable way for you to formulate your returns to the extent of making the best of all fees that's been gazetted and allocated to a specific action that you take. Before I go into the tariff itself, I'm just going to go through a few rules that appears on the Government Gazette, maybe not in the 2022 Gazette, but previous gazettes. Now, Rule 68.3a, it states where any dispute arises as to the validity or amount of any fee charged as where necessary work is done and necessary expenditure incurred, and there's no provision in the tariff for this fee, the matter shall be determined by the taxing officer of the court whose process is in question. Now, what this means, colleagues, is that although we have a tariff in the High Court, Rule 68, there might be certain actions that you would carry out in a scope of executing a document, and there's no provisions made for that specific fee. It does not mean you cannot charge the fee. You can charge a fee, but the execution creditor or the mandator has the right to tax that fee and allow the taxing master to adjudicate over that fee and see whether it's required or not, and whether you exceeded the requirements of the tariff. So yes, you can, under certain circumstances, charge fees that's not in the Gazette, but where you can justify and explain the fee. 68.3b, a request to tax an account of a sheriff shall be done within 90 days after the date on which the account of which the fees are disputed has been rendered. Now, 68.3b in the High Court reflects that the mandator has 90 days after the date of which the account was rendered. If you look at the Magistrates Court Tariff, Table C Part 2 of this year's Gazette, Gazette number 46475, the number of days has been reduced to 20 days. I do not see this amendment made in the High Court, so just be aware of that. Sometimes we might just look at the Magistrates Court and challenge an attorney to say, no, hang on, you got 20 days. But in the High Court, this rule has not been amended as yet. Just be aware of that, okay? Looking at the fees, you would notice that my table, I've allocated the relevant item or rule to the description and the fee, just so that when an attorney, very often we get attorneys calling the office and saying, but hang on, you charged X amount, can you tell me under what rule? So to make it easier for sheriffs and deputy sheriffs and office staff to understand the table, we've allocated the relevant rule to the description so that you are able to immediately inform the attorney the relevant rule. It's becoming more and more a requirement because just like us going through this financial burden and coming out of COVID over the past 2 years, attorneys are in a worse off situation. I'm sure as a practicing sheriff, you would have seen in the past couple of months or few months where attorneys are constantly saying we can't afford to pay the fees, or we want payment plans, we want extension to pay the area amounts. There's various explanations or requests are being made to sheriffs to give them a chance to make payment. So we are, after this increase, we are going to get a lot of queries from attorneys trying to keep our fees as low as possible. So I think upfront, I want to impress upon sheriffs to ensure that the fees that you log onto your computer, you should have done that by the 8th of July, on Friday, you should have done that. If you didn't update your computer system, my advice to you is immediately get your programmer, whoever runs your program, to assist your office staff update your program. And it's important to ensure that every description on your computer, fee description or tariff description, is looked at and the correct fee is put in there. If you do not understand how to do it, I'm hoping through the session you'll pick up a few pointers, but you're most welcome to contact the board or your colleagues to assist you update the programs. As the chairperson pointed out, that he is still seeing sheriffs not charging the correct tariffs. So this session is very, very important, colleagues. Reason being, we are at crossroads and we need every cent I should say, that we are entitled to come into that to our offices. So the fees are a very important part of our operation to keep us sustainable. I'm going to go through the fees where the fee does not require explanation. I'm just going to go through the fee, but where I feel that the fee requires a little bit more interpretation or explanation, I will give you the explanation. I'm also a practicing sheriff, so please bear with me if I make any errors. The tariff is fairly new to all of us, including myself, but I'm going to try my best to assist us understand the tariffs better.
Mr. Murray,
yes.
If I may interrupt you just for a moment, I already have two questions. The first is from, I think it's an internal question, so we're not going to pose that to you. I think it's best for Tane to pose that to either the legal or the legal and complaints committees of the board to deal with question number one. Number two, though, Sheriff Paul, and that must be Andrew Nkomise, ex-board member, is saying, is the time frame for taxation different from margin high? The reason I ask is that I think it's reduced from 90 days to 20 days after the return has been rendered. Do you understand that question, Mr. Murray?
Yes, I do. He is correct. There is a difference, as I mentioned upfront. The High Court Rule 68 has not been amended. Only the Magistrates Court has been amended. So your taxation, the attorneys or the mandator, as from the time your return is issued, the 20 days in the Magistrates Court, and currently, because the rule was not amended, 90 days in the High Court. It is from the time you issue your return of service.
Thank you, sir. Please go ahead.
All right. Moving on. The first item that we have on Rule 68 is your registration fee. As you know, it's gone up by 1 rand, which is now 13 rands. Your return of service. Now, here you would see the note on the side of the description. It says your return of service includes the original return and to the court and is limited to 1 person upon each original process. What does this mean? You'll find sometimes, I've experienced it, you find attorneys saying, but hang on, we want 1 return for 2 defendants. In other words, you must put the content of your service into 1 return. Now that's not possible. And a lot of attorneys are insisting on that, obviously to try and save costs. You are entitled in terms of Rule 68.7a to issue a return per defendant on as per the original return. So in other words, an attorney can't ask you to issue 1 return for 2 defendants. The rule requires to reissue 1 return per defendant. Thereafter, 7b requires you to issue a copy as well. So the fee of 52 rand includes the original return and a copy. The reason for that is obviously the original return would be lodged in court, and for the attorney to pay your account, the copy will be held back at their offices. So in terms of the rules, you are required to issue a return, an original and a copy. I know some sheriffs just give 1 copy or 1 original to the attorney. It's not right. You are required in terms of the rules to issue an original and a copy. 2A, the service of summonses, petitions, and notice of motions, notice of set downs, and court orders. The fee is 84 rand 50 now. That's the normal service of your summons in the High Court together with orders, notice of set downs. A fee 2A reads, 2.1 reads, a fee for each separate document except criminal cases, and the is 13 rands. So in other words, if you have a separate document attached to the summons, you're entitled to 13 rands plus your service fee of 84 rands 50. Okay. A lot of us don't read or don't go through these documents and we serve it and we just charge 84 and 50. My advice to you is look through the documents, your registration clerks, your reception, whoever does the sorting of the documents, and ensure that you look for these attached documents. You're finding a lot of attorneys now attaching, because of the amendments to the Magistrates Court Act especially, and the High Court Act, there's lots of arbitration documents coming through, which is a separate document from the summons. So you're entitled to the 13 rand or the service fee, depending what document it is. The attempted service of a summons, petition, notice of motion, notice of set down is 63 Rand 50. That is for your attempted service. Now remember, these fees are over and above your registration, your return, which is registration 13 Rands, returns 52 Rands, and then your service fee is of 84 Rand 50. And if you got a separate document, you add the 13 Rands as well. And not forgetting your traveling fee. Okay. Then we're moving on to the execution. Now, over the past 2 weeks or so, I've noticed a lot of queries being raised in regards to where is the service fee or execution fee for the writs. If you look at the table, the first fee is for personal arrest, including conveying person to courts, to any attorney's office, or to a prison. Per person is 106 Rands. To convey a person to court from place of custody on a day subsequent to the day of arrest and attending court per hour or part thereof, 126 Rands. It's very important, colleagues, for your deputy sheriff to ensure he notes the time he started the arrest and the time he finished in court. As you know, some of us wait hours in court for a magistrate or a registrar to attend to you, right? So it's very important for you to note the time that you're spending arresting the person and waiting in court until you are excused by the magistrate or registrar, right? So you charge 126 Rands per hour or part thereof. Okay, so in other words, for each hour you spent after that in the court. Attached to that is the next fee is attachment of property fundendum jurisdiction. Confirmation is 106 Rand. Now, we don't really carry out these services any longer, but we do get the odd ones out. So over and above your service fee, you will charge 106 Rand. Attachment of item 5A3 is withdrawn or suspended. In other words, if you're withdrawing an attachment in terms of the rule above, is 30 Rands. Your 5B ejectments is 126 Rands per hour or part thereof, subject to a minimum of which shall include the first hour in addition to your reasonable expenses incurred. Now, I know under this item, the fee is 188 Rands. Right? I know a lot of attorneys would query and say, well, hang on, you only allowed 88 Rands to do this ejectment. Colleagues, this rule is very clear. And what's the important part in this rule is any additional reasonable expenses necessarily incurred. So you are entitled to an ejectment fee that would obviously comprise of the work that you actually did to move these occupants out of the property. And it's impossible to charge 88 Rand for the attorney to say you're charging 88, you must charge 188 Rands for a complete ejectment, which took you 6 hours or 4 hours or 5 hours, and you moved a 5-bedroom house or a 3-bedroom house. So the important part of this rule is understanding what is the reasonable expenses you incurred to carry out the eviction over and above your 188 Rand or your 126 per hour. Okay. The traveling allowance, although the fee was not increased, but I think it's very, very important to understand the calculation of the traveling fees. And a lot of sheriffs have problems with attorneys when we charge our fees. Now, the rule is very clear that you're entitled to 6 Rands per kilometer, and you're entitled for the distance actually necessary traveled by the sheriff or the deputy sheriff from the office of the sheriff for both forward and return journey. So in other words, unlike in the past, you are now entitled, since the last Gazette, you're entitled to charge your going and your return trip on the traveling. But there's more, ladies and gentlemen. You obviously, in terms of 68A, you are to apportion your traveling. So in other words, if you're going on the same trip, the same direction with 5 documents or more than 1 document, let's put it that way, you are obligated to apportion your traveling. So in other words, your deputy sheriff must calculate the total traveling from office to the first document and the next document and thereafter, and obviously charge your traveling to that extent, apportion your traveling to that extent. So a bit of work needs to be done by your deputy sheriff to ensure that he notes the traveling distance from one point to the next in order to keep to this rule or to adhere to this rule. Further to that, if you have one document on the one trip, then you're entitled to your full traveling fee for the full amount of kilometers. Now, I do know that attorneys go on Google and they pick up the distance and they say, no, but hang on, you're not entitled to. But attorneys do not understand that the pattern of your serving is different from the Google pattern. But the only way you can justify your traveling is if you keep to the rules and obviously charge what is required in terms of the rules, in terms of traveling. Now, further to that, colleagues, your traveling allowance shall be calculated from the office of the sheriff or from the court, whichever is closer. Now, you need to determine from your office to the service address and from the court to the service address what is the closest to the service address and charge from that point. Those of us who are acting in appointments, or holding an acting appointment, it's very important for you to understand that you've been appointed for a specific jurisdiction and you're not appointed from your office. So in other words, you are obligated to charge the traveling for your acting appointment from the relevant court that you serve. In other words, if you're acting in an adjacent area, you're obligated to charge your traveling from that magistrate's court to that service address and not from your office. Right? That is the requirement. It's there, and we obviously ask you to adhere to that. Right? And the important thing is to charge from the office, from the sheriff's office or the court, whichever is closer to the service address. Now, I know attorneys really try and ensure that they understand the sheriff's traveling fees, because as you know, 6 rands a kilometer, although it's low for us, it is very low. It's non-viable at the moment due to the petrol increase, but they will still try and find ways to reduce your fee. And the only way you can overcome these queries or resolve these queries is to try as far as possible or to keep to the tariff that is gazetted. Okay. Mr. Nell, any questions before I move on?
No, sir, we are all good. Thank you very much.
I am now going to move on to Rule 68.5C, which is the immovable property. There's a number of fees under the immovable that's new, and also there's a number of new descriptions as well. And it's very important for us to ensure that we understand this tariff very closely, because this is where bulk of your fees would come from when you do immovable property. I know many of us are not getting immovable property recently due to the slow operation of courts and various case laws. But if you're doing excessive immovable property or you're doing immovable property, it's important for you to understand these fees very carefully. 68.5C1, which is the immovable property execution, including the service of the notice of attachment upon the registered owner and occupier, if the occupier is not the owner, is 251 rand. Now remember the note made in brackets there, which says if the occupier is not the owner. So in other words, if the owner is the occupier, then you're only entitled to one service fee. If the occupier is separate from the owner, then obviously you will charge separately. Then you are also entitled to a fee of the notice of attachment on the single lessee or the occupier. In other words, you'll charge the normal service fee, plus you'll charge for a notice of attachment upon the occupiers. And obviously, if there's multiple occupiers on the property, there's various tenants, you would serve each occupier with a notice, and for those occupiers, you will charge another fee of 8.50 rand per occupier. So, as I said, if you've got multiple occupiers on the property, you are obligated to serve each occupier and give them notice of the attachment, but they are different fees. So it's important to understand that for the first occupier is 23 rand, and further occupiers is 8.50 rands. Okay. Making valuation report improvements per half hour or part thereof. This is now, if you understand the Rule 46, last amendment, it is a requirement by the sheriff to carry out the improvements. I know a lot of attorneys would say, no, but we got the evaluation from the banks. The recent amendment, 2017, requires the sheriff to compile the improvements. So my advice to you is exercise your duty in terms of the rules, and obviously accepting the evaluation report from the banks, which is 10 years and 20 years old, can lead you into trouble. And the important thing is comply with the rules and obviously charge the correct fee. The fee states, the description states that you are entitled to 63.50 rand per half hour or part thereof. In other words, you charge 63.50 for every half hour that you spend on the property, taking the improvements or jotting down the improvements. The next fee is the attachment stayed or withdrawn. So in other words, if you're staying the sale and you're withdrawing the attachment, you're entitled to a fee of 251 rands at the High Court. Upliftment of judicial attachment on immovable property. If and when an attorney requests that you close your file and obviously withdraw the attachment, you will charge 251 rands as well. Obtaining conveyancer certificate ascertaining what bonds or other encumbrances are registered against the property, you are entitled to a fee of 126 rands. Now, I know here, some of the attorneys would insist that we take a deed search report and accept that as a requirement. The rules are very clear that you must have a conveyancer certificate in order for you to proceed further. And you are entitled to a fee of 126 rands to peruse and obviously ensure that the information is correct. Notifying execution creditor of bonds or other encumbrances together with names and addresses of the persons in whose favor such bonds or encumbrances are registered. Over and above, you will charge a fee of 23 rands per creditor. Okay. Considering proof that preference creditor complied with Rule 46(5)(a). Now, this is a notice where the preference creditor will inform, preference creditors are informed of the attachment made over the property. What this fee is all about is when you're asking your attorney to comply with your requirements, you would request that he informs the preference creditors. The preference creditors are your municipalities, your body corporates, your bondholders, if it's a private sale, those are your preference creditors. And obviously, the requirements in terms of Rule 46 is for them, the attorney or the execution creditor, to notify other preference creditors of the intended sale so they can set a reserve price, and you are entitled to a fee of 13 rands to inspect that return. Generally, you'll have your colleague who serves the municipality in your jurisdiction. The attorneys will get him or her to serve the municipality and provide you with the return, and that is the notice that I'm referring to, is when that return comes to you for you to inspect that return and ensure that service has been effected, your fee is 13 rands. Okay, notice referred to in Rule 46(6). This is obviously your bond documents. If you can find, if the attorneys furnish that to you, then obviously for you to inspect that document, you will charge a fee of 23 rands. That's before sale. Considering notice of sale prepared by the execution creditor in consultation with the sheriff, and verifying the notice of sale has been published in the newspapers indicated and in the government gazette, inclusive fee of 126 rand. In other words, for you to, when the attorney forwards the notice of sale to you for inspection, and when you are requesting the proof that the adverts were placed in the necessary newspapers and the gazette, you're entitled to one fee of 126 rands. You're not entitled to a fee of 126 rands to look at the sale notice and a further fee of 126 rands to verify the nature that the adverts were placed in the relevant papers. Right? Just remember that you're entitled to one fee for both actions.
Mr. Morgan?
Yes.
So Louise wants to know regarding the improvements where attorneys do not allow us to make use of a locksmith, and we can't get access to the to get to the improvements. How do we then go about it if the attorneys only supply the bank evaluation?
Look, we're going to deviate from the tariff training. That's Rule 46 training. It's actually a very what's the word that I can use? It's an issue that banks and attorneys are now refusing to adhere to. When the Rule 46 amendments were done in 2017-18, when the last gazette was made, the banking forum that sits with the profession and the board, at that forum it was agreed by the banks with the sheriffs that in order for the sheriff to compile the improvements, because it is a requirement, in terms of the rules that the sheriff must obtain the improvements. It was agreed at that stage that the bank would provide the indemnity to the sheriff after 3 attempts that he makes to compile the improvements. I am aware that the banks are refusing now to provide that indemnity. But as a sheriff, as a practicing sheriff, I would not proceed with allocating a sale date until I am indemnified to comply with the rules. And I know I've been challenged a lot by banks and attorneys, because what happens is the banks made the decision at that level, but they didn't filter that information down to the attorneys sitting on the panel. As I said, this is a separate discussion, but a very quick answer is, as a practicing sheriff, I would insist on complying with the rules. The valuation report is not a is not a legal require, at least it's not acceptable, basically, because the rules does not provide for it. I will not accept a valuation report, because remember, it goes one step further from here. It goes into Rule 46(9)(d), when you are doing a report to the court, where the magistrate or a judge wants to see the sheriff's proof that as he compiled the improvements, let me see what's the difference in the improvements in order for me to confirm the sale. So that is where the sheriff's responsibility eventually lands, back in court. So I would stick to the rules and insist on them indemnifying me, and obviously carrying out my duties. I know there's different schools of thought. Some sheriffs would say, no, Alan, I don't agree with you. I do not insist on the indemnity. I'm just opening up the place and doing my job. I know a lot of sheriffs think along those lines. I've had a lot of discussions with sheriffs, but as I said, the rules are clear. It is the sheriff's responsibility to compile the improvements. I'm going to leave it at that point, Mr. Nell, because as I said, it's a very in-depth discussion. It's not for this session, but that is my very quick answer. Forwarding a copy of the notice of sale to every judgment creditor who has caused the immovable property to be attached, and every mortgagee thereof whose address is known for each copy, 23 Rand. In other words, when the sheriff receives the notice of sale, he is obligated to inform all judgment creditors and mortgagees of the intended sale. So it is his responsibility to inform them, and obviously to provide that notice, he is entitled to a fee of 23 Rand over and above his service fees. Okay? Affixing sales notice to the, remember, all these fees does not go alone, colleagues. You got to compile your fees and understand that various fees you can charge in one return. And some of our programs have a facility where you can stack code fees. So in other words, you can take, for example, your service fees for a particular document, and you can stack code it on your computer. So in your program, so that your data capturer would know exactly for service of a summons, these are the fees I must charge. And if it's not charged, why am I not charging? That is how you would monitor whether you are maximizing your tariffs in your office to get the best out of the service and within the law. So my advice to you is, especially when you look at immovable property, there's a lot of fees that you can miss out, because a fee like 23 Rand, when your clerk is typing and she just puts a service, or he just puts a service fee there, and he mistakenly forgets about the 23 Rand. And if you do it 10 times in the month, it's a lot of money that's being wasted. So my advice to you is go through the tariff, set codes for a particular action that you carry. In other words, staying of sales. What are the fees that you would charge? Holding a sale, what are the fees you would charge? Making the attachment, what are the fees? And you go through the Gazette, and that is why you would find when I formulated this document, I formulated the document in such a way that it has all the immovable fees, all the movable fees, all the service fees separate, so that you would understand, or you can go through it and stack code your fees. Okay, we all use different programs, but I'm hoping that your programs do allow you to carry out this function where you can stack code your fees. It would really help your staff understand the fees and ensure that you're charging all the fees. Affixing notice of sale to the notice board of the Magistrates Court or the High Court in terms of Rule 46(7) and at or as near as may be to the place where the sale is actually taking place. An inclusive fee of 53 Rand plus your traveling fees referred to item 3. In other words, to affix at the court, if you don't have an High Court in your area, your Magistrates Court will be the nearest court for you. And obviously, if you're selling at court, then and at your offices. So a lot of us have our sales at our offices now. So to affix your sales notice at your office and at the court, an inclusive fee of 53 Rands. But you are entitled to your traveling fees to the court. Or if you are holding sales on the property, at the address that you're selling, then obviously you're going to place a copy of the sales notices there as well. So you're entitled to an inclusive fee of 53 rands, and you're entitled to your traveling fee. Okay. Rule 68(5)(c), considering conditions of sale prepared by the execution creditor. Now here, if you look at, there's an addition of 2 further fees for this function. In the old days, we just had considering conditions of sale, which was under whatever the fee was. Now it's 126 cents. But now, colleagues, you're entitled to a fee for considering the amendments to the conditions of sale. In other words, when the attorney sends you the conditions of sale within the time frames, you are entitled to inform the attorney, you're entitled to a fee to inform the attorney of errors that he made on the conditions of sale. Now, as you know, practicing shadows, you would find a lot of times we are obviously amending conditions of sale for attorneys because they don't put the proper or the required clauses in the conditions of sale, or they don't put the proper description of the property, the proper improvements. So each time you bring to their attention an amendment, you are entitled to 226 rands. Now, if they do it 10 times or 10 mistakes, you're entitled to that fee because obviously you are bringing all the amendments, all the errors to them. And if they don't amend it accordingly, you were entitled to a fee each time you request an amendment. That is what the rule states. Settling of the conditions, in other words, when you finally settle the conditions and tell them all is in order, I accept the conditions of sale, you are entitled to a fee of 126 rands. As you can see, just to attend to the conditions of sale, you're already entitled to a fee of 360 or 70 rands plus minus there. Now, a lot of us do not charge these fees. A lot of us are not aware of these fees that you're entitled. It's now the second gazette that these fees appear. So if you're not charging it, my advice to you is look at these fees and ensure that your clerks make note of the amendments that they bring to the attention of the attorney, and obviously the final settlement of the conditions of sale. And it's very important for the attorneys to give you correct conditions of sale because that is your purchase and sale agreement when you're signing with the purchaser. And if you do not amend accordingly prior to the sale, then you're going to have complications through the sale process or the transfer process or the application for rule cancellation of sale process. So please look at that. And here again, the stack codes help you a lot. All necessary attendances prescribed by any law related to auctions, in particular the Consumer Protection Act 2008-68 of 2008. Now this fee of 380 rands is for you to comply with the Consumer Protection Act. And what is this act? What functions do we carry out in our offices in order to comply with this act? Colleagues, it's your registration of your buyers, your collecting of the registration deposit, it's the request for the utility bill, the copy of the ID. So this is a fee for that function, for you to comply with that function. And if you are not doing this, if you are not registering buyers, you're not collecting the IDs and the utility bills as proof of FICA, then you need to start doing that. And this is a fee you're entitled to charge. Conducting an auction, save that this fee may not be charged if commission is claimed in terms of the rule. Now, this is a fee that's been queried by a lot of sheriffs recently. This fee comes in when you hold an auction and you do not reach the reserve price, where you obviously put up the property for sale, you went through the whole process of registering the buyers and carrying out the auction, and your buyers, obviously you announce that at your reserve price, or you sell subject to the reserve price, and you do not reach the reserve price, you obviously have to compile a Rule 4690 report, A90 report, and you obviously, although you collected the commission and you collected the deposit, it's not your money, it's still money that obviously not a sale that's not confirmed, so it has to stay in your trust until such time that the court approves or objects to this or denies the sale. So obviously, if the sale is cancelled by the judge, you obviously going to refund the monies that you held in terms of your deposit and your commission. When that happens, colleagues, you are entitled to a fee of 251 rands to hold that auction, over and above your other fees, your staying sale fees and your the fees that we just went through now, and your Consumer Protection Act. Over and above those fees, you are entitled to 251 rands. Okay. Considering notice of sale prepared by the execution creditor in consultation So there's duplication there. Your sheriff's commission on the sale of immovable property, inclusive in all instances of the sheriff's bank charges and other expenses incurred in paying the proceeds into his or her trust account to be paid by the purchaser, 6% of the first 100,000, 3.5 on 101 to 400, and 1.5 on the balance of the proceeds of sale. Now, this fee has not been changed from the last gazette. It still remains 40,000 Rand maximum and minimum 3,000 Rands. Okay, so there's no change on this fee as well. Let's hope that this fee changes in the next gazette. Okay. Giving written notice to the purchaser who failed to comply with the conditions of sale. And this is your notice to place him on terms. It's 63.50 over and above your other service fees. Report referred to in Rule 4611. That is now if the purchaser has not complied with the notice that you served on him and the attorney requests that you proceed with the cancellation notice, 63.50. Informing the judgment debtor of the cancellation referred to in 4611A. This is this obviously, if the court cancels the sale, you're obviously going to relieve the purchaser of the burden of the sale through the court's order. And what's very important, which didn't happen in the old days, is that once a sale is cancelled or immediately we sell a property, the defense, most of these defendants, they move out of the property, and they don't know that the sale is being cancelled. So in other words, if the sale is not cancelled, it's back their property. So now with this rule, the sheriff is obligated, once the order is received, to inform the judgment debtor of the cancellation. In most cases, if they're there on the property, you will obviously serve him the notice, and then he's not harassed or something to move out of this property. Okay. Giving notice referred to in 4611C is 23 Rands. Giving transfer to the purchaser, 30 Rands. So this is now when obviously you're signing your power of attorney to give transfer and obviously attending to the relevant requirements, you will charge 30 Rands. Receipt in terms of certificate referred to in 4614A. Now, colleagues, this is obviously a new requirement. This is, in the old days, we used to call it the certificate of balance, COB. In the amended rules, it's a certificate of all monies paid and owing to the debt or to the execution creditor. This is that certificate that we're referring to, is when you request, when you preparing your plan of distribution and you request the attorney to give you a certificate of all monies paid and owing towards the debt. It's very important for us to ensure that we just don't get a certificate stating this is the amount owing to the bank, 500,000. It's very important, Rule 4614A, when you receive the certificate from the bank, it must state the amounts paid by the debtor from the time of judgment to the time of sale, and obviously what is owing to the bank. And for that report, for you to inspect that report, you are entitled to a fee of 23 Rands. Preparing plan of distribution of the proceeds, including necessary copies, and for forwarding a copy to the registrar is 126 Rand. This as well is a new requirement, where in the old days, we never used to serve a copy of our plan of distribution to the registrar. Now you have to serve a copy of your plan of distribution to the registrar and to the debtor. So you will charge a fee of 126 Rands. Okay. Giving notice to all. Yes.
Richard Singh has asked a question in respect of the CPA. He's saying, is the CPA fee charged per file on auction, or is it per buyer that is registered?
Different schools of thought, but I think the most appropriate way to do it is per auction. Remember, if you charge per buyer, if you have 50 buyers at an auction at 380 Rands, it's going to be ridiculous. I don't think the legislator would write a rule in that manner where you would, obviously the cost of holding the sale outweighs the sale effect. So general practice among sheriffs is that you would charge the 380 Rands per file, per sale. In other words, you've got 10 buyers, you will charge 380 Rands for that file, not 10 buyers times 380 Rands for each file. It is a bit ridiculous to do that. Okay. And I don't think the legislator would write a rule to that effect. Okay. Giving notice to all parties who have lodged writs and to the execution debtor that the plan of distribution will lie for inspection for every notice, 23 Rand. This is where obviously you will serve, like the above rule, where you're serving the registrar, you will now serve the defendant and other parties who've lodged writs. Now, when they refer to other parties, is obviously you have, for example, your body corporates, your municipalities, your or participating writ that you had on file, to give them notice of the distribution account. And obviously they're within the timeframes that they need to comply to provide you with the necessary objection or acceptance of the distribution account. Report referred to in Rule 46A9D. This is your report when you don't achieve your reserve price, and you have to obviously inform the court that you didn't achieve the reserve price, and the court must decide on whether or not to accept your sale. To compile that report is 63 Rand 50. Now, I know a lot of shareholders would say, but you know, it's a lot of work to do these matters, but unfortunately, that is the fee that has been gazetted, and we're bound to this fee. Writ paid on presentation. Now, colleagues, now we're moving on to the movable property. Before I move on to the movable property, I just want to obviously stress again that especially with immovable property, there's a lot of fees that can be lost. My advice to you again, once again, before I move on, is to compile stack codes of your fees so that you obviously make the best of those fees. Writ paid on presentation, 9% on the amount so paid, with a minimum of 85 rands and a maximum fee of 832 rands 50. This is now when your deputy goes out to make an attachment and the debtor decides, no, hang on, I want to pay this debt. You would obviously calculate the debt through in conjunction with your office and the attorney, and obviously get the amount owing and outstanding as per the writ. And your maximum commission to collect the money is 832 rands 50 plus VAT. For an abortive attempted attachment, including 1 hour search and inquiry, your fee is 85 rands. This is now obviously you went and you try to make an attachment, you got a non-service, and the fee that you will charge is 85 rands. Writ stayed withdrawn before attachment is 30 rands. Making an attachment, including 1 hour search and inquiry, is 208 rands. This is now over and above your service fee and over and above your notice of attachment. To make the attachment, you will charge 208 rands. Okay, your notice of attachment to give notice to the defendant is 22 rands over and above your attachment fee. And to give a notice of attachment to each other person. So in other words, if there's more than one person on the property, you would give further notices or notice of attachment. The fee is 13 rands. Attachment withdrawn stayed before sale, 3% of the value of the property attached or the amount on the writ, whichever is lesser, to a maximum of 574 rands. Now, colleagues, this fee is quite important. Reason being, the fee is not 574 rands to withdraw an attachment. The fee is 3% of the value of your attachment to a maximum of 574 rands. So in other words, you need to calculate 3% of the value of attachment. In other words, the value that your deputy places on his notice of attachment, you will take 3% of that. And if it is below 574, then you will charge the actual fee of 3%. Only if it goes above 574, then you're entitled to 574. So my plea to you is ensure that when you're calculating withdrawal charges, you will charge 3% of the value of the attachment. I'm tempted to explain this further because, okay, I will explain this further when we get to the magistrate's court tariff, because there is a change in that as well. In the High Court, it's not used so often, but if you understand your Rule 45 rules, what's very important is when your deputies are placing values to your attached items.
Mr.
Yes?
Morgan?
Yes.
I'm so sorry. Anna, I don't know if that's Anna Ralishlaka, would like to know what if there is no response received from the registrar in terms of Rule 46A9?
Response, I'm presuming response from the court.
Yeah, from the registrar in terms of rule 46A 9.
Look, it's a legal obligation. It's a problem all over the country. Courts are not actioning this process very well. They're just not attending to these reports timeously. I mean, we got these reports sitting in courts for over a year. Some of us over a year now, where the courts are not granting these orders, especially in KZN. The courts moved premises and all our files are lost. So you're sitting for a year waiting for these reports. It has a very huge impact on the sale, especially the accumulation of the rates and levies on the property, because that purchaser is still obligated to pay all those rates that's accumulated for the time. It's a problem that we're facing. It's something that the profession and the board needs to take up with the relevant stakeholders, the Magistrates Commission or the chief registrars, or at least the your chief judges. I forget the name now, the title for these judges. Something needs to be done about it. I'm well aware of this problem, but unfortunately, the sheriff is not allowed to cancel the sale on his own. He has to wait for that report from court. The purchaser has to wait for that report from court. The sheriff cannot just randomly go and cancel the sale because the court is taking too long. You just have to follow it up with the court and request the file, or go and speak to the chief registrar, try and speak to the judges if possible, if you can, or your chief magistrates. You need to do much more to get those court orders from there. And that is why earlier on I said the fee of 63.50 far outweighs the amount of work we put into the these reports. And it's just a pity that the rules board don't understand the amount of work that sheriffs put into these reports. And unfortunately, an answer, or basically I don't have an answer for Anna. The only advice I can give is, because it's a legal obligation, it's in terms of the rules, what you need to do is you need to go to your registrar or to your chief magistrate or to your clerk of the court and impress upon them the urgency of finalizing your Rule 4690 reports. That's the only advice I can give, because it is stuck in the court. You cannot cancel the sale on your own. Okay, and the attorneys cannot request that you cancel the sale. Generally, what we do is we could get the attorneys also to go to court and try and put pressure on the registrars to find these files and obviously get the reports finalized by the judge. The sad thing is, even judges are not understanding these amended rules, and it's something that we all working to overcome, and obviously learning from one another, because it's a new requirement. Moving on, writ is paid after attachment but before sale, 9% of the amount paid. So in other words, before you make the attachment and the debtor wants to make payment, it's the same fee as the above, 85 Rand and 832 Rand 50. And obviously your other fees. Money is taken to execution, 9% of the amount taken, subject to a maximum of 832 Rand 50. Okay, same thing there. When you're collecting monies in execution, that is what you will take. In other words, when you attach monies in the bank, and in terms of Rule 4512A, the monies come to you and you're entitled to charge a commission of 9% with a maximum of 832 Rand 50. Drawing up advertisements for sale of goods attached is 85 Rands if you do it. It's very seldom that we draw up adverts now. Selling execution, including distribution of the proceeds of the first 15,000 or part thereof, and 9% thereafter, 6% with a maximum of 11,653 Rand 50. Okay, you're entitled to 9% with a maximum of 11,653 Rand 50. There's an error there. The 6% must come out. Okay. Commission shall not be chargeable against the judgment debtor on the value of the movable property attached and subsequently claimed by the person other than the judgment debtor and released in consequence of such claim, unless such property has been attached and the express direction of the judgment creditor in writing, in which event the judgment creditor should be liable for your commission. Now, in other words, the judgment creditor, if he is obviously requested that you attach and sell and hold the sale, obviously you are entitled to this commission. The commission in the movable property rules is different from the immovable property rules. In the immovable property, your purchaser pays the commission. In the movable property, you take your commission from the sale proceeds. You're not charging the purchaser for the commission. And this is the explanation given for that. Notice of attachment is 22 Rand. That is now when you make your inventory and you're giving notice. I think this is a repetition as well. I must apologize. Drafting interpreted summons referred to in Rule 58 is 800 Rands now. Ensuring movable goods attached when it is considered necessary and when the sheriff is directed thereto in writing by the judgment creditor in addition to the amount of the premium. In other words, when you attach movable property, you are entitled to insure the immovable property. In other words, if you're attaching very expensive and high-end items that you're going to keep in storage with you or on a third-party premises, you are required to insure that property. And it's very, very important that you consider the insurance, and you are entitled to the full premium, entitled to charge the attorney for the full premium to a further fee of 45 Rands. Keeping possession. For each officer necessarily left in possession, a reasonable inclusive fee per officer per day is 158 Rand. Okay. These are just the explanatory notes for the various descriptions. Possession means continuous and necessary presence on the property, in respect of which possession means a person employed and paid by the sheriff. In other words, if you're going to place somebody permanently guarding the attached property, then that is what possession means. For removal and storage, it needs reasonable and necessary expense for removal. In other words, I like the magistrate's court explanation. It gives you a more in-depth explanation of removal and storage, where you need to obviously go get quotations from your third-party removal or your removal company within your area to see what he would charge for your removal, for his removal, for the same amount of goods, and obviously storage. So you determine your storage and your removal along those lines. That is more or less how you will determine removal and storage fees. It's very important to understand this. Reason being, you get taxed a lot for removal and storage fees, and keeping to this requirement is important. So my advice to you is just get a general idea of the removal companies within your jurisdiction and what they would charge to store more or less the amount of goods that you are placing under attachment or in storage. Also, your storage cost, what is the general rate per square meter that other people are charging? And obviously, this includes your colleagues around you. What rate are they charging, what per square meter, and or if it's a different formula, what formula they use in order for you to keep in check with, or more or less in line with these removal and storage fees. Same applies to storage of animals in the stable and the feed for them. You obviously have outside service providers for this facility, and obviously your actual reasonable fees for that. Tendering livestock as well, your actual reasonable fees for that. Keeping possession. Yes.
Tell me, is there a fee irrespective of when you hand goods back to the debtor? Because Tertius would like to know, please advise what fee you will charge to hand goods back to the debtor. Don't we? Yeah.
Question is not very clear. I'm not understanding whether he is delivering the goods back to the debtor or whether he is whether debtor is coming to his premises and collecting. If the debtor is coming to his premises and collecting the goods, then there's no fee that you charge. You would charge a normal storage costs up to the day that the defendant will come and collect. Generally, sheriffs do not return the goods unless he is ordered to do so. If it's a normal attachment where the attorney would say, right, okay, release the goods to the defendant, the attorney would normally make arrangements with the debtor to come and collect his assets from the sheriff. The sheriff is not obligated to deliver the goods back. But if the sheriff is ordered by court to do so, then he must comply. And obviously he is entitled to a fee. And obviously, if depending on the court order, I'm not going to say the execution creditor or the mandator is liable to the fee. A lot depends on how the court order is drafted. The court order will direct whether the defendant in that application or your plaintiff is entitled to or required to pay your fee, or whether the debtor must pay the fee. A lot depends on how the court order is drafted and what the application was all about. That is the only time you would deliver back to the debtor. Generally, sheriffs do not deliver back to the debtor. Okay,
thank you. Then, and I wanted to know, in respect of interpleaders, who's liable for the 800 Rand?
Your instructing party. your instructing party, the attorney that requested the interpleader to be issued. Remember, Rule 58 and Rule 41 or 39. When you receive an interpleader affidavit, the rule provides that you inform your mandator that there is a third-party claim. And he is in the magistrate's court, he's got 10 days to respond to tell you whether he accepts the claim or denies the claim. If he accepts the claim, that means he's liable to the fees. If he denies the claim, that means he's accepting the affidavit, and obviously the attachment will be withdrawn. So that is where he becomes liable to your fees. And issuing the interpleader summons is not on the free will of the sheriff. He's obviously carrying out an instruction from his mandator, which is his execution creditors attorneys. So they are liable to the fees. I'm aware certain attorneys now refuse to pay interpleader fees, but the rules are very clear. They are the instructing party. They are required to pay our fees.
Okay, well,
it's very important. I must stress it's very, very important when looking at the fees to understand the rules and tie the rules to the fees. Just informing an attorney to say, I'm not crediting you, I'm entitled to this fee, without understanding or without backing up these fees to the rules, you will fail in your explanation to get through the attorneys. So it's important when looking at the fees is tying the rules to the relevant fee.
Mr. Morgan, I don't know if it was the previous slide or 2 slides ago. In respect of that 9% and 6%, now Tracy Swart says, good heavens, and others said 6% must be removed from Rule 5D, Roman figure 10. And she's clarifying that it must be 9% on the first 15,000 and then 6% to the maximum. Could you just clarify that for us and go back to that slide, please? I think it was 2 slides ago. That was Rule 5D 10.
Just give me a second. I just want to look at that rule. I also got it as that. It is same as she's explaining it.
Okay.
As she's explained it, it is there. I just want to verify.
Yeah, so let me just repeat that, what she's saying there, if I can.
Yeah, it is correct. The slide is correct as well. For stalling execution, including distribution of the proceeds on the first 15,000 or part thereafter, and 9%, and thereafter 6% with a maximum of 11,653.50. So that's correct.
That brilliant. Thank you very much.
So it's in other words, the explanation is, colleagues, 9% of the first 15,000 and 6% of the balance, subject to a maximum of 11,653. Just to clarify that point.
Okay, Mr. Morgan, since we have you on some questions, another question is, if an attorney does not respond to an interpleader, in other words, if they don't accept nor reject the claim within the 10 days, may the sheriff proceed with the interpleader summons?
In the magistrate's court, the rules are very clear that you can proceed with the interpleader summons if he fails to respond. The rules are very clear in that he's got 10 days to respond, failing which will proceed with the interpleader. The risk of that, certain rules in practice, sheriffs are very reluctant to proceed, because what happens is, should you proceed with the interpleader and incur a whole lot of costs serving those processes and what have you, you would have difficulty collecting your fees. So in practice, what we normally would do, we would keep track of the attorney, obviously within the 10-day period. Your movable clerk will keep track with the attorney to ensure that he provides you with an answer. And one of the ways you do it is obviously bring to his attention the requirement of the rules. And obviously try and push him to confirm whether he accepts or denies the problem. The difficulty is, although the rules is there and you got to abide by the rules, if he doesn't comply, you issue the interpleader. But one has to think further than that, especially now in the current situation we are, is how does it impact the claimant and how does it impact you in terms of incurring the fees? Who is going to pay you the fees if this attorney now refuses to pay. But this is why I'm saying it's very important on a daily basis to track these things with the attorneys for the 10-day period and get an answer from him, whether he accepts or denies the fees.
Mr. Moody, thank you very much for that explanation. May I just pose one last question, which says that most attorneys refuse to pay and explain that you did not remove anything. So what are you supervising? I'm not sure I understand that question, but maybe you as a sheriff understands what the question is.
You did not remove, but what are you supervising?
Yes.
Look, I'm assuming they're talking about keeping possession of the goods while under attachment. I'm presuming that. I might be wrong. I don't know under what context this question is being asked. I'm assuming that is this here for each officer necessarily left in possession, reasonable fee. I don't know, maybe it's that, but if it is that, then obviously, you see the I-Court rules, again, I'm going to say, it's very important to tie the rules to the tariff. Now, in the I-Court, the attachment does not lapse. Unlike the Magistrates Court, when you attach goods, it lasts for 4 months. Within the 4-month period, whatever you do, you do. And if there's nothing from the attorney within the 4 months, your attachment automatically lapses. So the attached goods are released back to the owner, to the defendant's control. In the I-Court, an attachment can lie indefinitely. Now, if you have movable goods under attachment, right? And for example, as you know, in the I-Court, an interpleader summons takes months on end to finalize. Sometimes it can take 2 years to finalize an interpleader summons. If you removed goods and placed into storage, while this interpleader summons is proceeding and you're sitting like 6 months to a year with the assets, obviously you're controlling those assets. It's under your care. That is why you're entitled to that fee. If it's that she is querying, then that is an explanation. Remember, a lot of these fees in the I-Court comes from old rules that was written. And attorneys, new attorneys don't understand these rules. So you are entitled to that fee for keeping possession of those assets under attachment. If you go to most sheriff's offices, you would find files that's 10 years old, 15 years old, 20 years old, and for movable property. Now, that is why in training, I always tell sheriffs, you've got to do housekeeping regularly in your office. You've got to constantly look at those movable files in your cupboards. I do it once a year. Towards the end of the year, I look at all files for movable attachments and do letters to attorneys, reminding them that we've got a file, or every 6 months you can do it, depending on your size of your office. Informing them that, hang on, this attachment is still here. What do you want to do with it? And attorneys sometimes forget that you even got an item in storage. Sometimes they release the they accept the final payment from the debtor. They don't come to the sheriff and withdraw the attachment because they want to save costs. And you're sitting on the file that's open. So what's important is for you to constantly remind the attorney that you've got a file open in the I-Court. Decide whether you still want this attachment to lie at least the assets to lie under judicial attachment. Or if you've got the goods in storage, Mr. Attorney, I still have goods in storage. Do you still want to for me to hold these goods? And where you can prompt attorneys to act is when you charge the fees. So in other words, if you put a bill to him every month for 158 rands for keeping possession, he's definitely going to jump and come and tell you withdraw this attachment if he's wanting to do that. So putting the fees in place in your office is very important. I'm assuming that's the direction of that question, Mr. Nell.
Mr. Nell, may I just come in quickly? Mr. Murugan, would you mind?
Yes, sure, come in.
Just to go back to the interpleader in terms of the High Court, I think it's pertinent that colleagues realize that the costs for an interpleader in the High Court is exorbitant. And the sheriff becomes the applicant in the High Court when an interpleader is drafted and when it's brought before court. It is imperative that sheriffs, when an attorney gives you an instruction to proceed with an interpleader in the High Court, to request that attorney to provide you with sufficient funds, whether it's 20, 25, 50,000 rand in your trust account so that you can do the disbursements for the attorney as well as the counsel that is being appointed to attend to the High Court as your representative, because, as I say, the sheriff becomes the applicant in the matter. And should you not do that, those costs are payable by you as the sheriff, because you are lodging the application. And through experience, through 3 or 4 High Court interpleaders in the last year, it was the best thing that could have happened, that we asked for big deposits in terms from the instructing attorney to pay it into our trust account, so that we could disburse funds that we incurred by, whether it's the attorney or the advocate acting on behalf of the sheriff. Thank you.
Thank you, Mr. Burton. Yeah, you're correct. In the High Court, obviously being the applicant, you are liable for setting the interpleader. Over the years, this process has changed. I know some sheriffs still do it the way you do it. Some of us have moved away from that because of the financial burden, and judgment creditors' attorneys refuse to settle the bill. So we obviously instruct the execution creditors' attorneys to represent us, and obviously they then carry the cost directly to the firm. In other words, they represent you as the applicant in the matter and not charge. In that way, you do not be liable for the paying advocates and paying attorneys or to attend to the interpleader summons for you. So there's 2 different ways of doing it. I know certain provinces strictly hands it over to your attorney, to the sheriff's attorney. Certain provinces give it to the execution creditor's attorney to act on behalf of the sheriff, in other words, to represent the sheriff. So obviously the costs are carried by the execution creditor's attorney directly with his advocate. So there's 2 different schools of thought or different actions that can be taken. But your process has been a process for many, many years. And you're right, the cost of these interpreters, if you're carrying the cost, is really high. And sheriffs should be very careful on when appointing attorneys to represent them for these interpreter summonses in the High Court. Okay. Copies of documents, in other words, to make copies, is R6.50 per page. Attending to criminal sessions of the Superior Court or any other circuit court is R5.74. We really hardly do this, but if you're carrying out these matters or attending to these matters, your fee is R574, 126 rands per hour, and maximum of R574. To write letters written, facsimile, electronic mail, including formal letters, accompanying process or returns, is 23 rands. Attendance of telephone calls, 20 rand. Now, colleagues, you must remember your telephone call, in addition, 20 rands plus your prescribed trunk charges. So in other words, you need to speak to your service provider, whether it's telecom, whether you have these private switchboard people who supply you with the telephone lines. You need to understand what is the charge per minute, or whatever the requirements are in, or whatever the process they follow, whether it's per minute or per 5 minutes or whatever it is. You need to understand that. So you charge 20 rand plus, if it's 5 rands per minute, 25 rands plus 5 rands, and how many minutes you spoke for, or how many minutes you attended to the telephone call. So remember, it's just not 20 rand, it is plus your actual cost of the call. Okay. Sending and receiving faxes, electronic mail per page, in addition to telephone charges. Here as well, although the email fee is R8.50, you are still entitled to the telephone charges for that email. And remember, it's an email per page, not per document. Now, I know the new trend amongst attorneys is that they would send you a 100-page email, a document that they didn't print in their offices and didn't deliver to your office. They now want you to carry out the entire process for them by receiving it by email, printing it, collating it, and obviously serving it. My plea to you is make sure that you're charging the right fee. It's not R8.50, and it's not R8.50 per document. It's R8.50 per page plus your telephone charges. So if you look above, your telephone charges is 20 rands. Now you need to determine what is the actual cost of the telephone charge, and you can determine that by speaking to your service provider. Bank charges, obviously, it's the actual bank charges that the bank would charge you. You need to understand what is the fee per 100 rands that the bank would charge, and obviously keep in line with that. Very important fee, where the mandator instructs the sheriff in writing to serve or execute a document referred to in item 2 and 5 on an urgent basis, or after to charge an additional fee, irrespective of whether the service or execution was successful, and such additional fee shall be paid by the mandator, save where the court orders otherwise. So in other words, you're entitled to an urgency fee of 283 rands, and this fee applies if you're serving documents after hours as well. So over and above your normal service fees, you will charge a further fee of 283 rands for that service. For the purpose of paragraph A, an urgent service means the same day or within 24 hours of written instructions. After hours service means between 7 a.m. in the morning and 1900 hours on Mondays to Fridays, or on Saturday, Sunday, public holidays. Now, you are entitled, obviously, to serve in terms of this rule between 7 in the morning and 1900 hours in the evening. I know it's not practical. This rule is not practical for us because after 5, you pay your deputies overtime. And in terms of this rule, your after hours only starts at 7 o'clock or 7 p.m. So it's something this fee needs to be looked at by the board, and obviously call upon the rules board to review these fees, this section of the fee. Because practically it's not possible for us to charge after 7 when you have a deputy who's being paid overtime from 5 o'clock onwards. So yeah, but this is the fee, colleagues, that you need to charge for urgency fee in the High Court. It's 283, and you're entitled to charge an after hours fee if you're serving after hours is 283. My advice to you is, when you're attending to matters of this nature, is to get it in writing from the attorneys. In other words, generally we sheriffs are getting lesser service during the day than after hours. In other words, there's a lot of people looking out for jobs, not at home. You're forced to go back after hours. And now when attorneys see this fee being charged over and above the attempted fee or the service fee, they're obviously going to query the bill. So my advice to you is ensure that when you're going after hours, is get it in writing from the attorney where he approves the after hours service. And then you're covered by a written letter from the attorney approving the after hours. Not just go there randomly and serve after hours, and then you find the attorney wants you to credit after your deputy has incurred the cost of traveling, petrol, time, the risk of going at night, and then the attorney insists you must credit the fee. So try and get written letters from the attorneys accepting your fees, which would help you when you go to taxation, if it's going to taxation.
Mr. Rudigan, excuse me, before you move on to the Madge Court, I think, excuse me, there was a gentleman called Jeffrey, who right at the beginning had posed a question for us and asked him to explain. And what I'm understanding now from his rephrasing of his question, he's saying doing different towns. This is all about the tariffs for traveling. So he's saying doing different towns, especially towns which are non-viable, and as I'm assuming these are mainly rural, and having an office. How do you charge for traveling? Example, traveling about 120 kilometers, one document to render a service. So I'm reading between the lines, thinking that he wants to know if he's traveling between towns, and he's, for long distances because of the rural areas. The principle that you applied to, if you're serving more than one document on a particular route, or you charge. So would that be the same for traveling when you have to travel these long distances to go and render a service?
There's 3 ways to look at it. Firstly, I'm asking a question. As I mentioned earlier on, if he is serving different towns, whether he's serving it as an ad hoc sheriff or an acting sheriff or a permanent sheriff. So in other words, if he's serving it as an ad hoc sheriff, then he's entitled to a fee from his office to the next town. He can charge his full traveling because an ad hoc appointment provides for that. If he's appointed as an acting sheriff in these various towns, unfortunately, the rule is, as I read out earlier on, he must charge from that court. So for him to get from his office to that court or to that jurisdiction, he cannot charge. He must charge from that court to serve the document to the furthest point, if it's the furthest point. If these towns are part of his appointment, then he will, and if it's one document from point A to point B, then he will charge full traveling. But if he's got 2 or 3 documents along the way to get, then he must apportion his traveling. So as I said, there's 3 ways to look at it. If it's an ad hoc appointment, he's entitled to the full traveling, apportioned if he's got a number of documents. If he's got 1 document, then he's entitled to the full fee. If it's an acting appointment, unfortunately, he can only charge from the acting appointment to that jurisdiction, within that jurisdiction. I'm sure building a relationship with the attorney in your area when you're serving, and if the attorney does not mind you charging the fee to get to that place, sometimes attorneys are more flexible. If they allow it, well and good. If they don't allow it, that is the rule. You need to stick to the rule. And obviously, if you're serving different towns within the same jurisdiction, appointed for the same jurisdiction, in other words, if you have more than 2 or 3 towns in your appointment as one office, then, and you have a number of documents on the same route, then you must proportion it. If it's just 1 document on the same route, then you're entitled to full traveling. I hope I made myself clear.
Great, thank you very much, Mr. Murugan. Just a very quick one for you here. From Tracy, I don't know how to issue an interpleader in the High Court. So I would have to appoint an attorney or an advocate. So who would carry those costs?
Okay, Mr. Burton gave us some understanding of that process earlier on, and I responded. Mr. Burton mentioned earlier on that he would normally ask for a deposit. Obviously, if you're the sheriff and you're engaging your own attorney, not the execution creditor's attorney, then you will request from your attorney what is the cost to carry the matter or to attend to the matter. And upon presentation of his invoice or a bill, you're going to go to your execution creditor's attorney and say, hey guys, this is the interpleader cost. This is what my attorney is charging me. Please pay a deposit into my account. That's according to now Mr. Burton's way of handling the matter. As I said, some of us don't do it like that. Some of us go to the execution creditor, in other words, the attorney that instructed me to attend to the attachment and the interpleader. We tell him, there's the interpleader. We prepared the interpleader. It's been issued. That's the date. You get, obviously, we're serving the execution creditor's attorney with the copy of the interpleader and the summons. There's the interpleader. You've been served. Please represent me in court and inform me of the outcome of the matter. So in that way, there's no financial burden on the sheriff. I know in the old days, these High Court interpleaders were very complex, and there is a risk preparing it on your own if it's a very complicated matter. So some sheriffs are afraid of attending to it on their own. They would rather give it to an attorney to do it. Some of us are able to do it on our own, and obviously, understanding the process, we would prepare the interpleaders and obviously ask or request the instructing attorney to represent you. So as I said, there's 2 ways to do it. There's no rule preventing you from doing it on your own, and there's no rule strictly telling you must appoint an attorney. But because you're the applicant, you would obviously do it the way you feel most comfortable with. And as Mr. Burton pointed out, the cost to run an interpleader in the High Court is really, really huge. So you wouldn't want to carry that burden.
Mr. Murugan, thank you very much for that explanation. I know that you are going to move into the Madge Court now, but I'd just like to, for the questions that are coming up in respect of the CCMA, let me just quickly inform all attendees that the board is in fact currently busy trying to secure well, I think it'll be a couple of hours as you and I have discussed, a workshop with the CCMA, the National Bargaining Councils, as well as, of course, the management, as Mr. Burton has, I think, pointed out, management from each of the CCMA offices throughout the country, so that we can get a response from all of them all at once. So we won't deal with any of the questions from the CCMA in this session. We are trying to secure another Zoom session with the parties directly, so that you can hear it from them. Mr. Murugan, we are really pushing for time now, but I do not want you to rush through it. I'm sure colleagues they're finding this most interesting, so please, we'll try not to disturb you too much as you go through the Madge Court, unless there are pertinent questions. Thank you, sir.
Thank you, Mr. Nell. Colleagues, we're now moving on to the Magistrates Court tariff, Part 11 of Table C, Part 2, Annexure 2, sorry, of the Magistrates Court Act 32 of 1944. Again, Gazette number 46475, gazetted on the 3rd of June and came into effect on the 8th of July 2022. Okay, I'm very quickly going to go through Rule 34.2a, 34.2b. It's supposed to be 34 there, sorry for the error. Not 4.2b, it's 34.2b. Colleagues, something that needs to be taken into account, it's very important for us when we get these gazettes, is to understand the fees, whether there's anything missing from this gazette as compared to the previous gazette. I always compare the previous to the new to see if there's anything they omitted. And in most cases, these gazettes, the Rules Board leaves out a lot of fees and descriptions. Now, 34.2a, every account of the fees or charges furnished by the sheriff shall note the following. You may require this account to be taxed and vouched for before payment. So in other words, every return of yours must have this note at the bottom of the return. If your returns do not have this note, but generally most computer programs carry this as a watermark on your return. So try and ensure that you do have this in your returns. And, you know, for many years, the Magistrates Court rules tariffs were really prescriptive. In other words, you didn't have the ability to go and charge fees that were not in the tariff, Table C, Part 2. You were bound to the tariff. If there was nothing in the tariff, you couldn't charge. But in the previous Gazette, in the 2020 Gazette, Rule 34.2b was introduced. Now, this rule is same as Rule 68b in the High Court, wherein you are now allowed to, obviously, I wouldn't say allowed, you now can charge a fee if you charge a fee. I'm not saying you must go and charge fees that are not gazetted. If for any reason you carried out an action as per court order, warrant of execution, something that you ordinarily don't do, and you had to charge a fee, you were forced to charge a fee, you are now required, the judgment creditor, can request that you tax that amount. And if you can prove to the taxing master a valid reason for charging that fee, he can allow it. So in other words, you are allowed to charge a fee for actual work carried out, obviously reasonable, and if it's not in the Gazette. So this rule will help us in terms of charging a fee that's not in the Gazette in Table C, Part 2. Remember that, okay? And please note, it's not Rule 4.2b, it's 34.2b, okay? Okay, item 33 is the item that now has been amended, wherein you have 20 days. A request to tax an account of a sheriff shall be made in writing within 20 days after the date on which the account of which the fees are disputed has been rendered. So in other words, after issue of your invoice, your return of service, the attorney has now 20 days and no longer 90 days, as was the case before. 20 days to request you to tax your bill. Okay. As I said, very quickly, we're going to go through these fees. Magistrates Court is much more straightforward than the High Court. Registration of documents for both service and execution is 12 rands. Return made, original and a copy, is 19 rands 50. And for service of your summonses, subpoenas, notices, and orders from the courthouse or your office, whichever is closer, is 48 rands for 0 to 6 kilometers, 57.50, 6 to 12, and 77 rands 12 to 20. Now, this fee is excluding your traveling fee. Now you are entitled to charge your traveling fee to and from whichever point is closer to the service address for the going and return trip, right, over and above your service fee. For the attempted service of these documents mentioned above, you will charge for 0 to 6, 41.50 plus traveling, 6 to 12, 48 rands plus traveling, and 12 to 20, 69 rands plus traveling. Okay, I don't think there's any more to explain in that. But as I said, that is the fee you charge. Now, obviously, I mentioned earlier on in the High Court that where a document must be served together with the process of court is mentioned in the such process as annexure thereto, no additional fee shall be charged. So in other words, your particulars of claims to a summons or annexures to a summons, annexure ABC to a summons, you can't charge an additional fee. But if you have an additional document related to that matter, then a fee of 12 rand can be charged. Okay, no fees shall be charged for criminal cases as a separate document. Okay, I'm going to go down to the 1BC, where a mandator instructs the sheriff in writing to serve and execute a document referred to the above on an urgent basis or after hours. The sheriff shall charge an additional fee of 256 rand, similar to the High Court, upon instructions from the mandator to serve their document on a same-day service or an urgent service or an after-hours service. You're now entitled to charge 256 rands. If you remember, in the old days, the fee was double the service fee. Whatever your service fee was for that specific radius, you would simply double it. Now you're entitled to charge 256 rands as the urgency fee if you're serving the document within 24 hours. And again, you're entitled to charge 256 rands for after-hours service. Okay, so remember, as I mentioned earlier on again, it's very important to get this mandate in writing so that you know when the fee is eventually charged and there's a dispute, you have something to fall back on. As I mentioned earlier on, there's the urgency fee of 256. The Magistrates Court has been amended or aligned to the High Court rules if you look at the time of service. This was different in the Magistrates Court for all these years. Now it seems like they aligned it to the High Court, which is 7 o'clock to 1900 hours, which most sheriffs would not agree with, because obviously the circumstances that we operate under these days forces us to go after hours for most of our documents. And most of us pay our deputies overtime, or the deputy sheriff earns commission to work after hours. So the timelines needs to be reviewed and looked at again. Okay. If it is necessary for the sheriff to return a document received by him or her before service or execution to the mandator, the address for service, if the address for service does not fall within his jurisdiction, or the mandator stops service or attempted service, then it is 12 rand. So in other words, if you receive a document and the address does not fall within your jurisdiction, you're only entitled to charge 12 rands to return the documents, and not a service fee. Some of us charge service fees. You're not entitled to a service fee, you're only entitled to 12 rands plus your registration and your return, not your 0 to 6, 6 to 12, or 12 to 20 fees. For execution of warrants, immovable property interdicts, other than immovable, only warrants for movable property. You will charge 0 to 6, 69 rands plus your traveling, 6 to 12, 77 rands plus your traveling, and 12 to 20, 96 rands plus your traveling. Okay. And even in this case, in the Magistrates Court, it's very important, or it's very good, I can only advise you, is to develop stack codes for various actions in your office. In other words, for movable property, what are the fees? How do you put these fees together so that your clerks can learn the various smaller fees that's coming up? Every 3 rand lost in your office, or 23 rand lost in your office, is money lost at the end of the month. So my advice to you is develop stack codes in your offices. Attempted execution, 5750, 0 to 6 kilometers plus traveling, 6 to 12, 69 rand plus traveling, and 12 to 20, 86 rands plus traveling. Okay, your traveling expenses is 6 rands at the moment, and the explanation to the traveling is the same as the High Court, wherein if you appointed an acting appointment, you can only charge from the acting appointment jurisdiction. And obviously, if you got more than one document, you must proportion that document. And also, colleagues, something that I omitted to mention earlier on, is if you're serving more than one defendant at the same address. In other words, if you got 2 defendants at the same address, you're only entitled to 1 traveling charge, not 2 traveling charges, because you're going to the same place. It's a single trip there, and it's the same address you're serving. So remember, if you've got 2 defendants at the same address, it's only 1 traveling that you're allowed. Okay. Continued on the explanation of the traveling. I just mentioned it to you now. Okay. I'm going to run through that very quickly. We'll just go through the summarized explanation. As I said, your traveling cost is 6 rands. Sheriff is now entitled to charge the gazetted fee for service execution plus the traveling to and from the service address. The sheriff is required to calculate the traveling charges from the office or to the court, whichever is closer to the service address. The sheriff must proportion his traveling cost amongst the number of documents that are being served on the same trip. Traveling costs will include all added expenses. If there is only 1 document on the trip, then you are entitled to charge the full cost. If service is effected on more than 1 person at the same address, only 1 traveling charge. That's just the summarized notes that are made for you to, obviously, this document will be provided to you by the board, so you can obviously have those notes, and for your clerks or your staff to look at it and understand it. For ejectment of the defendant, exceptional except extraordinary expenses necessarily incurred, is 41 rands per hour or part thereof. My explanation on the ejectment earlier on is the same as this. Okay. A further fee after execution for every person and above the person referred to in the process of the ejectment. In other words, if you have more than one occupier on the property, some of these properties have various tenants, 27 rands per person to give notice of the eviction. Okay. Conveying a person arrested by the sheriff or committed to his custody from the place of custody to the court on a day subsequent to the day of arrest and attending at court per hour or part thereof is 41 rands per journey and 77 rands per hour or part thereof to attend court. So it's very important, as I said, if your deputy is sitting in court for more than an hour, then he needs to make note of the time that he's sitting in court and charge a relevant fee. And you are also entitled, colleagues, is a traveling fee for that, to transport that data from point A to point B. And in some cases, you're transporting it back to the address. So you're entitled to the separate traveling cost for that. Okay. Making inventory, including making all necessary copies, including time spent to take stock, 41 rands per hour or part thereof. This is now when you make an attachment for movable property and you're making the inventory, you're entitled to 41 rands per hour or part thereof for making that inventory. For assistance to make inventory is 41 rands per hour or part thereof. Generally, we have deputies assisting one another to make the attachment, or especially when it's a big attachment that has to be done. So this is the fee you will charge for your deputy assistance, 41 rands per hour or part thereof. Okay. Perusing, drawing up indemnity, bill, bond, deeds, or suretyship is 12 rands. In other words, when you request an indemnity from the attorney, when you're proceeding with sale, and they provide you the indemnity for you to verify whether the indemnity is correct and it covers you, your fee is 12 rands. For each officer left on the premises per day is 142 rands per day. As I mentioned, if you obviously on the property, you're making an attachment or you attending to a removal, that's your fee that you would charge. For removal, livestock, removal and storage, the explanation is the same as I mentioned earlier on, is obviously get a quotation from neighboring sheriffs or service providers within your jurisdiction. It's good to get quotations from service providers outside your profession to understand or to convince the taxing master. This is where what other service providers are charging for the same type of work carried out. Livestock as well is the same explanation, where the actual expenses incurred at the pound, and obviously the necessary expenses to feed the animal and obviously medicate the animal while it's under storage in the pound. So all those costs added to your return. If goods are removed and stored, only the cost of removal and storage is allowed. So in other words, if you're removing and storing, get quotations for storage costs within your jurisdiction and obviously charge more or less within that time, within those rates. Same as possession in the magistrate's court. In the High Court, as I explained, possession means actual physical possession of the assets within your control or within the control of your service provider that you appointed. Okay, let's just give a further explanation on the removal and storage costs here. Your sheriff's commission, where a warrant of execution or garnish order is paid in full or part thereof, 9% of the amount, with a minimum fee of 76 rands 50 and a maximum of 752 rands. It's straightforward, colleagues. If you're collecting money on a garnish order or on a warrant of execution, that is the commission you would charge. For the execution of any warrant against movable property, when a warrant is paid in full or in part thereof, 9% of the amount paid, with a minimum of 76 rands 50 and a maximum of 752 rands. Straightforward. When a warrant is paid in full or part thereof, the sheriff after attachment before sale, 9%. In other words, if you got your writ in the office and the guy wants to come to your office and pay, that is the fee you will charge, 76 rand minimum and 752 maximum. And same goes for monies taken into execution, 9% of the amount taken. In other words, if the debtor wants to make payment, that is what you will charge him. Notice of attachment to a defendant and each other person is 12 rands to give notice of attachment. Okay. Colleagues, release of attachment, Rule 4118A, or the warrant of execution is withdrawn or stayed, or the judgment debtor's estate has been sequestrated after attachment, but before the sale, 2.3% of the value of the goods attached. Now, this is a very important requirement. It's something if you didn't pick up in the latest amendments to the Magistrates Court Act, there is a provision now in the Magistrates Court Act, colleagues, in addition to the rules, 41, the rule is 4115A and B, and 4116A and B, please go back and read that rule. It's an amended rule or an addition to Rule 41, wherein the judgment debtor, together with someone of means, can now stop a removal by issuing an indemnity to the sheriff. So in other words, if an instructing attorney requests that you go out and remove the goods and place it under storage, and you're out there and the judgment debtor now says, no, hang on, I want to hold these goods until the day of the sale, and I want to give you an indemnity. Now, most of us, if you didn't read the rules, there is a rule that provides for that now in the magistrate's court. So in other words, that debtor, together with someone of means, in terms of Rule 41(15)(a) and B and 41(16)(a) and B, is entitled to give you an indemnity to cover you. From what I've seen recently, is they are taking the value of the attached goods. In other words, the value that your deputy places on the attached goods. That is why I say it's so important for us now as sheriffs to relook at the way or the manner in which deputy sheriffs or sheriffs are evaluating the assets. Now, it's a gray area in the sheriff's profession because there's no set formula to evaluate attached assets. We just take a general understanding of what you get from auctions, or we decrease the value, a new price by 2 to bring it to a second-hand value. That's the unofficial way of doing things. There's no set way of or set formula to evaluate goods. But the important point that is being made here is for you to understand the amendment to Rule 41, Sub-Rule 15A and Sub-Rule 16A and B, wherein the judgment debtor now, together with someone of means, when you're out there to remove, can present an indemnity, and the rule states clearly, to the satisfaction of the sheriff, right, to present the goods on the day of sale. Now, even here, the legislator didn't take the variables into account. I mean, if the sheriff holds a sale, has allocated a date for sale, and the judgment debtor gives you an indemnity to say, I'll bring it on the day of the sale, the sheriff has to sit and wait for the goods to arrive at his premises. It's going to cause lots of hassles, and I've already experienced it where judgment debtors want to action that part of the rules. And attorneys are looking at it, judgment debtors, defense attorneys are looking at it to save the goods from being removed. And the important thing is, I've noticed that they are going on the value of the attachment made by the sheriff. Right now, if your deputies are under-evaluating these assets, it can cause a very huge impact on the judgment execution creditor's claim should the debtor run away with these assets between the time you went to remove and the date of the sale. So it's something that the profession as a whole needs to look at, because it's just recently amended. We were so engrossed in looking at Rule 38, we obviously not paying too much of attention to this sub-rule. I know it was addressed in the workshop, but it's important for us to look at the sub-rule because more and more attorneys are going to rely on it. And my advice to you is, what the point I want to bring home is, make sure our deputies are evaluating these goods properly and placing the proper value to the item, because we don't want to place, for example, if a truck is worth 300,000 and our deputy values it 50,000, and when you go to remove, the debtor gives you an indemnity for 50,000. The difference there is very great. So let's try and educate our deputies in terms of understanding values placed on attached assets. That's the point I want to make. I want to stress upon. Okay, the fee for that is maximum withdrawal fee is 227. And also in this rule here, you will not charge the full 227. You will charge 2.3% of the value of the attachment made. In other words, 2.3% of the actual amount your deputy places as a total on his notice of attachment. If it exceeds 227, then you're entitled to charge 227 maximum. If it is below 227, 150 Rand, then you can only charge 150 Rand. Just remember that, okay?
Mr. Morgan, just before you, if you may just, I'm waiting for a little while here for Khabai Piwe. Khabai Piwe wants to know, Mr. Morgan, can you kindly elaborate more on movable property? 8A1.
Item 8A1 on my slide.
Yes. Let's just see. There we go. There we go. Can you just go back there and just explain that in a little more depth?
Well, I've been explaining that quite a bit in the High Court and in the Match Court just now. It is when you make an attachment of assets, and obviously attachment is the goods are under your control. The attached goods is under your control. You will charge a fee of 141 rands per day. In other words, permanently you got an officer looking out for these goods, or you appointed a service provider to take care of these goods while it's under attachment. It's 42 rands per day. Let me give you an example. In the High Court, you got Anton Puller orders where you pick up computer systems and software programs and stuff like that, and you got it in storage. Obviously, it's under your care. You're taking care of these items every day. So you're entitled to charge that fee to keep possession of those items, right? Similarly, if you got items left with a service provider, outsourced a service provider, you're entitled to charge a fee of 142 rands per day to take that. Now, remember, it could be a gray area allocating a fee for a private service provider as compared to your deputy, because it's specifically saying an officer left on the premises. So if an attorney wants you to allocate a deputy to be with him for a day on the premises to make an attachment, you're entitled to that fee. I hope I'm making sense. Could be a different explanation. As I said, some of these things are gray areas, different interpretations by different people. That is my interpretation, has worked for me. And we did discuss this interpretation recently amongst sheriffs, and more or less we came to the same conclusion. Could be challenged, but that is the basic understanding, because it's very clear. It says that if you're leaving an officer on the premises, in other words, if your deputy sheriff is left on the premises to take care of the attached assets for the day, that is what you would charge. But generally, we don't get that instance. Maybe in the old days it used to work, where you call out to do these things. I don't know, maybe with the warrant of arrest suspectus de fuga, where you're allocating a deputy to sit with the debtor for the whole day, or you're holding a vehicle for some reason under attachment on a property or something, where you're placing a guard to protect something. I don't know, maybe it's for that. But it is something that the rules board didn't explain or elaborate in the rules. It's just been carried forward over the years without an explanation. They don't elaborate on in the rules. Movable property sold in auction, commission of 9% of the first 15,000 or part thereof, thereafter 6% with a maximum of 10,018 rands 50. Okay, doesn't need explanation. You calculate according to the percentage allocated, and obviously to a maximum of 10,018 rands 50. Insurance is the same process as I explained in the previous High Court tariff, where the actual cost or the actual premium that you would pay your insurer plus a fee of 41 rands to keep those goods under attachment. Okay, this item here is quite important, especially now with all the fuss about online auctions and carrying out more advertising of your immovable property or your movable property. It says, in addition to the fees allowed in item 10 to 13, both inclusive, they shall be allowed a sum actually and reasonably paid by the sheriff or the auctioneer for printing, advertising, and giving publicity to any sale or intended sale and execution. So in other words, if you have an item that deserves more awareness, if you've got a very good property that you're selling and you know that your buyers would not give you what you want from the sale, and you need to expand the viewing of this property, then obviously in conjunction with your attorney, you would obviously extend the advertising requirements for that particular sale. Now, it says printing, advertising, and giving publicity to any sale or intended sale and execution. I'm also assuming it's just a rule that just popped up in the Gazette without properly explaining to shareholders what it is. And I'm when I look at this rule here, I think when online auctions come about officially, this rule will allow for shareholders to charge those fees for the advertising on your websites. Or currently, if you're advertising your sale on your website, you're entitled to a fee. The rule is there, and it appears in both I and the match court. So are now moving that direction where we place our sales on websites and online auction sites and stuff where you're maximizing your awareness of your sales. You are entitled, the rule is there, you're entitled to the fee. And if you're taken for taxation, you're covered by this item. And obviously, working with conjunction of the attorneys concerned. Okay. Okay. This doesn't need any explanation, it's straightforward. This as well, straightforward. Fees payable on the value of the goods attached or on the proceeds of sale and execution shall not be chargeable on such value or proceeds as far as they are in excess of the amount of the writ. Right? Fees and expenses of the sheriff in execution of the garnish order shall be added to the amount to be recovered under the order and shall be chargeable against the judgment debtor. Straightforward. Point one is obviously fees payable on the value of the goods attached and the proceeds of the sale shall not be chargeable on such value or proceeds for such far as they are in excess. In other words, your fee should not come more than the writ amount. And generally, if the value of the goods that you're attaching exceeds the writ, then obviously it creates a problem for the execution creditor. And very often execution creditors wouldn't want to pay those fees that you're overcharging or you charge when you're placing values. And this is my point I made earlier on, colleagues, is it's very important when your deputy sheriffs are evaluating goods to give the true reflection of the value of the goods to the attorney. In other words, your notice of attachment must properly be compiled with a very close value of the assets. So understanding valuation is important and determining the correct value is important. Same goes for at least the garnish order. Obviously, we know that when you are serving a garnish order, which is very little these days, you would add your fees to that garnish order. Perusing, examining, and indicated newspapers and gazette in which the notice of sale has been published is 12 rands, straightforward when you're perusing your adverts. Affixing sales notice on the notice board or the door of the courthouse or other public building and at or as near as may be the place where the said sale is actually taking place is 28 rands plus your traveling. In the magistrate's court to prepare and interpret a summons is 209 rands. As you know, in practice, sheriffs prepare these interpreter summonses and obviously request the attorney to represent him and proceed with the interpreter and obviously give him the outcome or inform him of the outcome of the interpreter. We're moving on to the immovable property, Rule 43 of the 43 and 43A of the Magistrates Court Act 32 of 1944. Very quickly as well, it's the same description as the High Court. As you know, these descriptions have been aligned and the rules have been aligned to that of the High Court, obviously changed between 46 and 43, but the sub-rules are more or less the same. Okay. Execution, including service of notice of attachment of the defendant, occupier, and registrar is 227. Serving an occupier with the notice of attachment is 21 rands. Identical notices, as I said, if there's more than one occupier on the property, you've got to give notice to these occupiers at 7 rand 50. Compiling the improvements valuation report for the purpose of improvements and sale, 57.50. Immovable property stayed, withdrawn, and the attachment uplifted is 227. Ascertaining bonds and encumbrances, 114 rand. You'll notice that the fees differ from the High Court to the Match Court. In the High Court was 126, now it's 114. So it's important. In the previous Gazette, it was the same, more or less the same. So just be careful. You need to look at the fees in the Magistrates Court. It's totally different from the High Court. Notifying the execution creditor of the bonds and encumbrances, 21 rands. Considering proof that preference creditor complied with Rule 43.5a. This is the notice when the attorney is requested to serve the preference creditors, the municipality, body corporates, other bondholders. If it's a private sale, preference bondholder is 12 rand. Notice in terms of 43.6 is the obtaining the bonds on the property, at least the Well, yeah. Considering notice of sale and verifying notice of sale published in the Government Gazette and newspaper, inclusive, in other words, you're entitled to one fee of 114 rands, not per publication. Forwarding copy of notice of sale to every judgment creditor who has caused the immovable property to be attached, and to every mortgagee whose address is known. For each copy is 21 rand. This obligation is the sheriff's obligation, wherein you, upon receipt of the notice of sale, you will obviously serve. By looking at the conveyance certificate, you will pick up who are the mortgagees listed in the conveyance certificate, and you will serve the relevant people. Remember, sometimes you would find there's more than one bondholder to the property. So if you're selling for bondholder A, you are obligated in terms of the rules to serve bondholder B and C and D. So remember, you got to give notice to the different bondholders. As long as they're registered as a bondholder in the CC, you need to give them notice, okay? Affixing copies of the notice of sale to the notice board, the magistrate's court, and as near as maybe the place of the actual sale taking place, similar to the High Court, 49 rands plus your traveling cost. Considering and settling conditions of sale for each attendance, 114 rands. It's not as broken down as the High Court. High Court specified the different actions. Here as well, it's the same thing. You will consider amendments to the to be made. You will consider settling the conditions of sale. Right? Each attendance is 114 rands. Then your CPA attendance for the magistrate's court is 343 rand. As I said, it includes registration of the buyers, complying with FICA, collecting your IDs, collecting your copies of the IDs, collecting the utility bills, collecting your registration deposits, paying it back out, and obviously keeping records of these documents. Right? Conducting of the auction, save that this fee may not be charged if the commission is claimed, similar to the High Court. If the sale is cancelled for some reason on your 4390 report, then obviously you're only entitled to 227 and not the full commission that you would have charged at the sale. Remember that if a sale is cancelled in terms of Rule 4390, you are not entitled to the commission. The rule is very clear, the conditions of sale is very clear, that the commission must be refunded together with the deposit. So it's advisable for sheriffs to ensure that until the report is finalized, the sheriff's commission and the deposit is held in the trust account. Your commission for sale of an immovable property has not been changed. It's still the same, 6% of the first 100,000, 3.5 on the balance, 3.5 on 101 to 400,000, sorry, and 1.5 on the balance, including of all bank charges and expenses incurred in placing the money in your trust account. Okay, it's a minimum fee of 3,000 and a maximum of 40,000. Okay. In the magistrate's court, there is a provision for the execution creditor to appoint a private auctioneer, should he require. If an auctioneer is employed as provided in 4310, 3% of the first 100,000, 2% of 101 to 400,000, and 1% of the balance, inclusive in all instances, the bank charges and other expenses incurred in paying the commission, paying the proceeds into your trust account. A minimum of 3,000 rands and a maximum of 22,850 rands. Now, a lot of times, or sometimes, you get attorneys trying to push us and apply this rule to the High Court. It cannot be done. And we urge sheriffs not to comply with that because it's strictly in the magistrate's court and not the High Court, this provision. Written notice to purchaser or fail to comply with the conditions of sale is 57 rands. Report in terms of 4311, that is now when the purchaser didn't comply with your notice placing him on terms, your report cost is 57 rands. Informing the debtor of the cancellation, once the court has granted an order to say the sale is officially cancelled and to forward that report to the debtor, you will charge 21 rands. Giving notice in terms of Rule 4311C, 21 rand. Giving transfer to a purchaser, 27 rands. Receiving a certificate in terms of Rule 4314A, 21 rands. This is your COB. So in the old days, COB, now we call it a certificate of all money is paid and owing on the judgment amount by the judgment debtor. Your plan of distribution of the proceeds, including necessary copies and for forwarding to the registrar, is 114 rands. As I said, these are all new tariffs that came in, all new requirements, aligned. It's aligned to your rules that
that was amended recently. Okay. Notice to all parties who have lodged writs and to the execution debtor that the plan of distribution of life for inspection is 21 rands, and proof report in terms of 43A9D is 57 rands, and if an immovable property lapses is 69 rands. Right, the general fees that we would charge, ladies and gentlemen, is your letters written, facsimile, excluding formal letters with accompanying processes, is 21 rand. Telephone attendance, including, now it's supposed to be excluding prescribed trunk charges, sorry, the error there, is 20 rands. Sending and receiving faxes per page in addition to telephone charges, in other words, same as the iCourt, you would charge 7 rand 50 plus the telephone charges. Okay, there is the rule that I highlighted up front. It's actually in table item 33 of the rules, but I brought it up front just so that we can highlight it and make you aware of this amendment. A request to tax an account of the sheriff shall be made in writing within 20 days after the date on which the account of which the fees are disputed has been rendered. Is now from 90 days moved to 20 days. Drawing up a bill of taxation and attendance of the taxation by the sheriff is 77 rand. It's very important to note, colleagues, in the magistrate's court, the responsibility to draw up a notice of taxation is the sheriff's. In the iCourt, the instructing attorney can proceed to draft out the taxation notice. So there is a difference between the iCourt and the Mag Court. So remember that in the magistrate's court, it's your responsibility. In the iCourt, the attorney can do it on their own. Okay, and obviously we would have to comply with that requirement or adhere to the taxation notice and respond to the taxation notice. Okay. Bank charges are actual costs incurred or charged by the bank for bank charges. Okay. Drafting notice to judgment debtor in terms of section 65(8)(a)(b) of the Act and service of the notice referred to in paragraph A, the tariff has prescribed in 1B, and attempted service of the notice referred to in paragraph A, tariff as prescribed in 1BA, and the tariff as prescribed in 4 shall apply. So in other words, a fee of 21 rand. This is a notice when you give to the debtor informing of the section 65 or warrant of arrest that you have for him, giving him a notice to say that you have the section 65 for him to appear in court, or a notice to inform him that he's going to be arrested. Okay, that is what it is, a fee of 21 rand. Okay. For the arrest and attempted arrest of a debtor, judgment debtor in terms of section 65(a)(6), for handing over the judgment debtor to the South African police or the friend of the court or to the clerk of the court, traveling cost for the place of arrest and handing over to the relevant authorities referred to in paragraph A per kilometer 6 rands, and waiting time in regards to handing over the judgment debtor to the relevant authorities referred to in paragraph B. Your traveling cost is 6 rands per kilometer for the journey and 41 rands per hour or part thereof, and a maximum of 151 rands to convey this person to court. So in other words, you're entitled to your fee of minimum 41 rands per hour or part thereof for the maximum of 151 rands. You're entitled to your traveling time to take the debtor to court and back. So pay very careful attention to this rule, because it accumulates 2 or 3 fees that you're entitled to charge. You're conveying the person, your arrest, your service or your execution, and your traveling for the time that you spend in court. Okay. If you didn't notice that the recent Gazette 46475 also add an amendment to Rule 43 as part of the amendments to the tariffs. I added it in here just so that, just in case we didn't pick it up as yet. Rule 43 is actually your immovable property rules under Gazette number 46475. I see there's an amendment made where the rules board now state that the substitution for paragraph 9B and subrule 1 of the following paragraph. It states the substitution reads as follows: a warrant of execution against immovable property shall contain a full description of the nature, magisterial district, physical address of the immovable property to enable it to be traced and identified by the sheriff. Now this rule has been amplified a bit. They made it more specific to say what the sheriff must look for. So most of us have a letter that we send to attorneys when they request a sale date, and we give them our requirements. And obviously, when the writ comes to you, you need to inspect. Before you get to the sale, before you ask for your requirements, or before you make the attachment, this is what the writ must look like. It must have the description of the property. It must state the magisterial district. It must have the physical address. Some attorneys insist that they just put the physical address and not the property description. Now, remember, in the deeds office, even in the municipality, to inquire at the municipality, they would want the AF description. Deeds office strictly works on the AF description. They don't work on the physical address. So it's very important, and it's good that the rules board has now emphasized on these requirements. Further to that, they went and said in item 2, sufficient information to enable the sheriff to give effect to sub-rule 3 hereof, including a title deed number, AF number, sectional title unit number, and exclusive use area to enable the register of deeds to identify the immovable property and record the attachment as an interdict against the property. As you can see, if you got immovable clerks sitting on the session, or sheriffs who handle the immovable property on their own, you would see it has now been amplified with more requirements that the attorneys have to comply. So what is our responsibility as sheriffs is when the writ comes to us, we need to make sure that we tick off all the requirements that have been complied with. By now, we should have amended our requirements in our offices to obviously inform our staff of what they need to look for on the writs. And remember, if you don't get this right up front, your whole process of the attachment is going to fail. Or you'll get a technicality at the end of the sale where the judgment debtor might challenge the attachment that you made based on this sub-rule here. Okay. Same with the 4311. Any loss sustained by reason of the purchaser's default may, on the application of any aggrieved creditor referred to in paragraph 14C, be recovered from the purchaser under judgment of the magistrate given in a written report by the sheriff after due notice in writing has been given to the purchaser, and that the report be laid before the magistrate for the above said purpose. This is your chamber book application, rule 4311B. Right? That is now obviously when you're doing your application for cancellation, this rule will apply or be one of the requirements in your application where you're asking the judge to consider this as well. Okay. Colleagues, that's my story. We've come to the end of the session. I'm hoping that colleagues have understood my explanation. If there's any further questions, something that I didn't explain carefully, you're most welcome to send your queries to the board, and obviously they can attend to it via there. Before I hand over to Mr. Nell, I'm going to take this opportunity to thank the chairperson of the board and board members and management of the board for giving me this opportunity to address the tariffs and obviously part with some knowledge that I have on this subject. I'm hoping that I've attended to some part of your queries that you might have had, or further explained certain fees that would assist you apply the fees correctly in your offices. As I mentioned, the trend to go, because of the fee increases, because of attorneys not doing well as well, a lot of attorneys are battling out there. It's very important to have a very strong credit control system in your office. Applying the fees, charging the fees is just one aspect, but collecting the fees, making sure the money comes into the bank, paying your obligations, and making sure that you're running a sound office is another part of the action. And that is, most importantly, running an effective credit control system. And understanding the whole idea of presenting this fees in this manner is for you to understand the fees. And obviously, when attorneys are raising queries with you in regards to the fees, you would know where it comes from. And you would know, obviously refer to the breakdowns that was given to you, and obviously answer the attorneys as quick as possible so that you can get paid as quick as possible. Police, once again, thank you very much. Thanks to the board. Thanks to the chairperson and Mr. Burton for affording me the opportunity. Thank you, Mr. Nell.
Thank you, Mr. Morgan. Before we let you go, let me just inform you that there were other questions, but because we were running a little over with our time, we were running a little late. There were a few other questions, but I didn't pose them to you. And I'd like to know, is it at all possible for you to, if these questions from these particular participants if we could forward them to you, or if you mind, if any of them, anybody that participated today, contact you directly to pose their questions. Some of them pertaining, others maybe just outside of the scope of today.
I don't mind, Mr. Nell. If you want to send it to me, I can answer it and send it back to you, or the sheriffs can contact me. I don't have a problem with that. I'm available. You have my details. You're most welcome to give it to them.
Excellent. That's absolutely brilliant. Thank you, Mr. Murigan. I'm going to ask, I see both our chairperson and Mr. Burton, the chair of the training committee, is available to us. But before I hand over to Mr. Burton, and then the last person to speak today would be our chairperson of the board, Advocate Morgan. Let me just quickly remind the participants, and thank you for staying late, it's appreciated, that the session on the Poppy Act on the 16th at 12 o'clock till 2 o'clock. Please register as soon as possible. And we can only send you a link if you've registered. So we want you to get, once you receive the email, and that's going to be sent out tomorrow, the invitation, please go online, register. Now, the ladies have asked me to please ask you, when registering, your correct email address that you would use when participating in the session. That is the email address that you need to furnish. Please do that for us. And with that, thank you very much. Please complete the evaluation forms, which should be in the chat function. And I'm going to hand over to Mr. Burton firstly, and then a final say to the chairperson. Thank you very much from us, Mr. Murigan. Thank you very much for assisting us today.
Thank you, Mr. Nell. Just allow me this opportunity to express my appreciation for everything that went on behind the scenes. The ladies in the engine room who kept the Zoom going. Most of all, Mr. Murigan, for preparing and facilitating the session for us. Thank you very much. Your input and your knowledge and the sharing thereof is much appreciated. Mr. Nell, for putting everything together, thank you. And most of all, for Advocate Morgan joining us in this session, sir, thank you. It is great having you with us. And just as a final word, gents and ladies, the Poppy Act session will be on the 16th of August, and not this coming month, but it's 16 August. And please, from my side, especially the deputies and the sheriffs, you need to have the people that attend to the physical services every day. They need to attend this knowledge that they are going to obtain in terms of what is going to be shared is imperative. It is so important to know what they can share and how the Act works together with the rules. But thank you very much, Mr. Advocate Morgan. Over to you. Thank you, sir.
No, thank you very much, Mr. Burton, the chairperson of Training and Development. I'd like to also express my sincere appreciation and gratitude to Lucinda and Benedine and Candace, who made it possible in assisting Mr. Nell and Mr. Burton to have this program going. As well as a special thank you to you, Mr. Murigan. Thank you for never getting tired of our invitations to facilitate these important training programs for us, because Section 8 of the Act reminds us very well what the objects of the South African Board for Sheriffs are. And it is through you that we are able to fulfill that very important statutory function that we are called upon to fulfill. So thank you very much, Mr. Murigan, Mr. Burton, and your team. It's all inclusive of Mr. Nell and his team, because it is under your auspices that we see such good training initiatives by the South African Board for Sheriffs. And colleagues that have joined, I see we have over 90 attendees. Sheriffs, thank you very much for taking the time to attend, deputy sheriffs as well as office staff. to gain more experience and exposure and knowledge in this important on this important topic. And I would also suggest in a light manner for them to attend the more trainings that come, because I'm assured, or I should at least assured, that from these 80 or so sheriffs that have attended, I will not be seeing a complaint or a disciplinary matter that comes to the board regarding their matters. Then they come and they say, we didn't know. You know, ignorance is not an excuse in law. So for those that didn't attend for no reason, I'm afraid if something is done and it comes to our attention and they could have gained experience and knowledge from these training platforms that we provide, which come at a great cost, I must emphasize, ignorance will not be an excuse when you are before a disciplinary hearing and we look back onto these registers and you didn't attend, more so. In fact, that would be used more as an aggravating than a mitigating ground for whatever sanction that the board asks for. So thank you very much for those that have attended. I know that it is worth your, it will be worth your while and beneficial in the long run for all of us. Thank you very much, and please stay blessed and God bless. Thank you.